Welcome to the Business SOS podcast. This is Rich Sierra, president of the Florida Small Business Legal Center. This is episode 151 of our podcast. Thank you for listening, and I truly appreciate your time and your support. And I hope that the information I provide to you is valuable to you and your business. So I've been talking about litigation for the last few episodes. So today I'm going to talk something a little bit different. Think about this scenario. You work, say 20 years building a business. Say you build a restaurant for a number of years, and you're ready to retire, and then you want to sell that business. So you get a business broker to help you, give you advice on how to get the business ready to be sold. And I think I've spoken about this before. Just like when you're going to sell your house, you kind of go ahead and, paint your house. You take care of any scratches. Anything has to be fixed. You fix it before you actually list it for sale. So the business is no different. You want to sell your business, so you want to make sure that your books and records are accurate, that are current as well, that you have filed all your tax returns, that all your payroll taxes are paid, that any type of liabilities that you have are paid as well, that you don't have anything regarding the structure of the business that you're going to be providing as part of the due diligence. It is well. So you do kind of a pre-due diligence check before you actually list it for sale, because you're going to be asked those documents. So you go ahead and get that done. You talk to your CPA, you get the business broker involved, you talk to your business lawyer, say, I want to sell my business, what do I need to do? And you go ahead and get everything done right. The reason for that is because you will be doing what is called warranties and representations as part of the the asset purchase agreement or stock purchase agreement, that you will say that there are no liens in the business, that there are no outstanding liabilities in the business, that the business is operating as it has been in the past. There's no foreseen events in the future that you know of that will dramatically decrease the projected revenue that the business has been making for the last year, for example. So there are no really material changes to that business, so the new owner can come in and continue that business as you're running it. There might be some changes, but for the most part, nothing dramatic will happen once the business or the new owner takes over. So you go ahead and get all that done. So as part of the deal, say you get the business broker involved, you get a number of offers. Say you want to sell it for $500,000, and I'm using that just as an example, of course. And you go ahead and get a couple of offers come in, and some of the offers say, an offer could be something, we'll go ahead and buy you business for $500,000, or say for $50,000. People usually try to lowball you for the initial offer you have. Say we'll buy it for $450,000, for example, and we'll pay $350 cash at closing, and you finance $100,000. It's not the offer that you want, but you turn that one down. And then you continue kind of negotiating, and, say you get the price that you like, that you want to go ahead and get the $500,000. And you get the $350 cash, but you finance $150. And you ask, what is finance $150? What does that mean? Well, today, that's the topic of today's podcast. I want to talk about things that can go wrong and how you can protect yourself to the best that you can when you're financing a portion of the sale of your business. Because what happened is that has been circumstances that I get calls that people sell their businesses, they don't go through attorneys, and they get some cash, and then they do a very rudimentary promissory note, sometimes even a handshake agreement, that the new buyer or the buyer will pay back a portion of the financing. And then I get the call, well, stop paying the financing, stop paying the loan, and I want to enforce it. And that's where the problem comes in. That's where the situation comes in. And I get questions sometimes from clients that are selling the business and say, well, how can I guarantee that that note will be sold? The financing, I'm sorry, that promissory note will be paid, or the financing that I'm offering will be paid. And my answer is there's never a guarantee of that. There's no guarantee that you will get paid. The guarantee that you will get paid if you get all the money up front when you sell your business. That is your best guarantee. I'm not saying that if you finance a portion of your sale, that is wrong. I mean, there are a lot of ways to structure a deal. Financing is part of it. Recall when I sold my company, Healthcare Recruitment Online, many years ago, a portion of the transaction was financing, and it was paid. So there's nothing wrong with it. It is how it is structured, and understanding that when you're financing a portion of that sale, you're lending money to the buyer. You're becoming the buyer's bank. So as long as you understand that and know that you're taking the risk that there's a possibility that you might not get paid, just understand that. What probability there is, I don't know. It depends on the transaction. And it also depends on the due diligence that you do from the sellers, from the buyer side. Remember that the buyer is doing due diligence on you, going through all your financials, going through your banking records, going through your contracts, going through your, client list to the extent that you can disclose it before closing, going through your payroll taxes, going through your operations, lien searches, everything, to make sure that what the buyer is buying, it is a viable business that is worth investment. Likewise, if you're going to be lending money to that buyer, because that is basically what you're doing, if you're going to sell your business and portion is going to be financed by you, you should conduct similar due diligence. And I'll go over that in more details shortly. But it is not, they should not take offense if say, well, what are your financial qualifications? How do I know that you're going to pay me? And what assurances I will have? I mean, who's going to guarantee that note? And what happens is that when the buyer is looking to finance, looking for you to when the buyer is looking for you to finance a portion of the sale, 9 out of 10 times is because the revenue of the business is going to be paying for that loan. And they do it for a number of reasons. So in essence, the business is paying for that loan. And number two, they want the owner, the seller, in this case, to kind of stay in touch with the business to maintain that continuity in that transition. Because that if there's a loan out there that you're going to be getting paid from that business, you have vested interest for that business to be successful at the very least until you get paid. Because otherwise, we're not going to get paid. So let me go into more details. Okay. So one of the problems that happens here is that you sell your business and then they start making payments on the note. Say it's a 2-year promissory note, for say $150,000. In 6 months, then they stop paying. Then you have calls, say what's going on, what happened here. Well, things are slow. I'm waiting to get more revenue or sales, and I'll pay you. So they missed the first payment. Okay. Then they missed the second payment. Then that's when you call an attorney. You call me. I look at the documents. Let's assume the documents are correct, and you have a valid promissory note. It is enforceable, and you have an acceleration clause. We'll talk about that shortly. And then I'll send that demand letter, requesting the balance of the note. Say, for the sake of argument, it's about $165,000. No, actually $145,000. And what I get back in many cases is a letter from another attorney saying, rescinding the promissory note and saying that there were some material misrepresentations made by the seller with respect to the financials that were provided as part of due diligence, and the business is not generating the same revenue that was anticipated or promised when they bought the business, when the buyer bought the business. Granted, I'll go back to you, say, no, that is not correct. I provided all the financials. Here they are. And you did all the due diligence. And there are two ways that can be resolved. That can be resolved through a negotiation to the other side or through litigation. This is when it gets interesting. So, depending on the balance that you have to make the calculation, the balance that is owed. You have to make the calculation, how much am I going to spend on trying to collect the balance of that note? And what I see happening here, in many cases, is that the buyers use that as a pretext to discount the note significantly and not pay it at all. And I've seen that. Is it fair? No, it is not fair. But it happens. And I want to make you aware of that. If you're looking to sell your business with some financing involved, that there could be a possibility that you're not going to see that money. So how can you prevent that? You can reduce the risk, and I think that's what we can do. We can reduce the risk of you not getting paid. And one of them would be to make the note smaller. Don't take that huge risk of, $100,000, $20,000 note. And I've seen deals in which the seller finances 90% of the note, of the selling price. I think that's a huge risk to do that. But every deal is different. So one of the ways that you can protect yourself from a potential buyer not fulfilling the obligations of the transaction, in this case, a promissory note or a financing that you offer as part of the sale, reduce the note so that way you reduce your risk. Second way you can do that is by reducing the time period where that note has to be paid. So instead of a 24-month financing, you can offer a 12-month or 6-month or 12-month financing. So it reduces it significantly. So that way the risk continues to go down. Okay. Another way that you can have that in a promissory note, obviously this goes with the caveat that if you're going to be selling your business, my recommendation is to get an attorney who's handled these transactions to help you, especially when you're going to finance the transaction, because there's a risk that you're taking. And more of an aside, that something that you can do if you're not really that comfortable with the financing is maybe reduce the purchase price to make it more enticing, or provide an incentive to the buyer to pay you everything in cash. So that way you eliminate your risk. Again, the way you can eliminate your risk is when you're selling your business, get everything up front. If you're financing a portion of that sale, you're taking a risk on that purchase, and you may not see that money coming to you. But what if you do? What can you do to create safeguards to increase the probability of that note being paid. One of them is have a security agreement attached to the promissory note, meaning that you have security interest or a lien on the assets of the business. And there's a separate document that is prepared that is attached to the promissory note that can also be enforced. In a practical matter, when you sell your business, you don't want it back. So I'm not sure how that is going to help you unless there's an asset in that business that you can collect and sell to be able to pay the promissory note. Could be a patent, could be something, valuable for that business. But you don't want to, practically, if you sold that business, they don't pay you back, you want to take over the business, very likely you're not going to take that over. But what you can do is file a UCC1 with the perfecting a security interest by filing a UCC1 with the Florida UCC. What that means is you're perfecting your security interest, and it becomes a public document. It is not difficult to do. It's a form you fill out. You send it with, I believe, $30, $35. And what it does, it just puts everyone in notice that the new owner will not be able to sell that business without releasing that lien that UCC1. So that is important. If by any chance a buyer buys that business with that UCC1, you might be able to collect your promissory note from that new buyer, because the buyer had notice of the lien and bought it anyway. Most of the time, when there's due diligence, an attorney from the seller side will go through UCC1, does a lien search, finds UCC1 and said, we need to get this paid before to be able to close. Not a problem. If the seller, the new owner, the person who bought the business from you wants to sell, they can sell, but as part of the closing, funds are set aside to pay the amount that is owed, and then you release the lien. So at the very least, you have something there that will protect you in the case he sells it to somebody else. And it's a very cost-effective way to protect your interest, but also you will get paid right from the closing proceeds by filing that document. So something that I highly recommend. Another thing that I recommend here, and again, it all depends whether the buyer is willing to do this or not, is to have a personal guarantee on that promissory note. And they can say, well, this is kind of a business deal. I don't want to do that. You don't have to agree to the financing offer. You can say this will only be sold on a cash basis. There's nothing that obligates you to sell your business offering from financing. So if the buyer does not want to buy it without financing, move on. You can say, okay, we'll get somebody else. But if you're going to offer financing, it is okay to do it on your terms. When they go to the bank is going to tell them, we'll lend you money, but these are the criteria. This is the conditions by which we'll lend you money. Otherwise, we're not going to lend you money. Likewise, if you're going to be lending money to the buyer to buy your business, it is okay for you to create some criteria to do so. And you can say right from the very beginning, I'm happy to provide financing, but this is what I need. You can have some financial statements from the seller. What are they, statement of cash flow. Okay. You can ask for a personal guarantee. You can actually, make it clear that you will have a UCC1, a finance security interest in that promissory note. You can also say, okay, if you default in that promissory note, I'm not going to chase you, and because I'm not going to chase you and start creating a lawsuit. No, you will agree to a final judgment right from the very beginning. If you default, you waive all defenses. Because I'm not going to be going to court fighting over you not paying me the money that you agreed to pay me when I sold you the business. Now, that doesn't mean that we'll agree to all terms, but you can ask for those. That in the case of a default, after due notice, you agree to have the full final judgment for this amount, upon affidavit of the owner or the attorney. That can be done. So again, this is about reducing your risk and increasing your probabilities of getting paid. Because remember that you are the one lending the funds. You're the one financing part of the sale. If they don't want to do it, they can always go to a bank and borrow the money. So I just want to make it clear that you're not obligated to offer that as well. And the promissory note should include a provision for attorney's fees as well. I've seen promissory notes that no provision for attorney's fees. There's no acceleration clause, and no default provisions, no terms. I've seen them open say that there's no terms when the promissory note will be paid. It is surprising, but I've seen those in this 21 years. So the key here is, if you're selling that business, get professional advice, get professional assistance to do it right. So that way you increase your probability of getting paid. Something else that you can ask for, and again, it all depends what they're willing to agree and what you're willing to accept. At the time that you actually have a security interest on that business and you have they owe you a promissory note, they owe you some money, you can ask for financials every quarter, see how the business is doing. You have the right to ask for those financials. It's not uncommon for banks to say, okay, we'll lend you the money, but we want financial statements every year. Or at any time that we ask, if we ask for financial statements, you provide it to us within 10 days. So you can create some conditions to make sure that you have the ability to request that to have some assurances that the business is doing well enough for you to get paid. You also can have provisions in the asset purchase agreement as well, that while the promissory note is still outstanding, the business cannot be sold, even though you already have some provisions on the with the UCC1 and also with the security interest. You already have some safeguards there where you can put it in the contract. Say, if you're about to sell the business, you need to be notified to make sure that your balance of your promissory note is paid first. So you're always in touch. I mean, I've had situations that people call me about sold this business, and then I just found out it was sold and they still owe me money. And I said, okay, send me the promissory note. That's a good promissory note. I said, do you file security interest? The question is, what is that? Or financing statement. What is that? No, I didn't do that. So there's some mistakes that can be made here. And then what happened is you got to chase the buyer who already got paid from that second sale and is gone somewhere. You got to chase him for the money for not paying the promissory note. It would be very difficult to sue the new owner of the company because the owner did not have notice of that promissory note outstanding. So just something to keep in mind. Yeah, I do. So what happens if they don't pay you and you have to sue? Okay. So in that case, I recommend you get an attorney and you make that determination based on how much money is owed. And that calculation has to be made, if you look into something, if the promissory note is less than $15,000, for example, then something you can do is small claims. You don't need an attorney for that. Most jurisdictions have small claim packages that you can just fill out. It's very simple. Some of them even do it online. So small claims might be an avenue to do that. If you do, as a promissory note that is owed over $15,000, then you're looking at county court if it's less than $50,000. I'm talking about Florida, of course. Anything over $50,000 is circuit court. I've litigated some of these, and what I see happening is there's usually a counterclaim for some type of misrepresentation. Usually the word fraud is included there as well. And it is done in a way to create this litigation to not to pay the note. And it becomes a battle of resources as well. If you have the money to litigate, then it's something might be worth pursuing. If you don't, then the better option might be to consider negotiating that note down and get some money in. And that's usually the motivation that what I've seen is from the buyers when they counterclaim for something they received, even though you have provided it and you have defenses, you can go ahead and prove that. They already know that it's going to cost you more money to litigate this than the amount is owed. And 9 out of 10 times, most of these cases settle without going to court. So you'll have to make that consideration that if that happens, you may have to negotiate a discount on that note to get some money versus no money. And you have to pay fees on top of that. So that's the calculation to be made. But it's a standard breach of contract claim, breach of promissory note claim. But the other side has defenses. And they can come up with anything with respect to whether or not the financials were correct. And then they have to hire an expert to make the determination whether or not the information you provided was accurate. Despite of the fact that many of these agreements contain a merger clause that state that all representations that have been made, merge into this document. And also, the deals that I do for representing the seller, I make the buyer sign a document clearly stating that they have conducted a due diligence and they're satisfied with the due diligence. No additional information is requested and they're satisfied. So that way there's no question that there's not something later on. So, well, I did not get this document and I found out this about the information that I did not have before. So there's so many safeguards that we can provide to protect you from, not getting paid in a financing of a business that you're selling. There's so many things we can do. That still will not guarantee you payment. That still will not guarantee you that you were going to get paid. It increases the probability, but it's not a guarantee. So if you want a guarantee of getting paid on your sale of your business, then the only way you can do that is getting that money up front, negotiating a cash deal with no holdbacks. So that way everything comes to you, you sell your business, you move on. But when you have a deal that is financed, then there's some things that you got to put in place to make sure that at the very least you've done everything that you can within your power to make sure that you're getting paid. See if I cover everything. I mentioned to you that this is something that an attorney should do. If you're selling your business, I recommend don't do this yourself. You make a few mistakes that you're not going to get paid on that note. This is good for now. I appreciate you listening today. This is, again, episode 151 of Business SOS podcast. If you have any questions about this subject or any of the subject that I've spoken to, please, you can reach me at rich@richsierra.com. I want to thank my beautiful wife here. That's my live studio audience. Hi, who's taking some pictures and videos of me while I'm doing this. Thank you for being here. If you want to check out our legal services, my website is floridasmallbusinesslegalcenter.com. My phone number is 866-842-5202. We're on Facebook and Instagram at FSB Legal. We're also on YouTube. If you want to watch the video of this podcast, go to youtube.com/@RichardSierra. Remember, it's Rich Sierra from the Florida Small Business Legal Center. Remember that my goal is to help you succeed.